Testing, testing.
Sorry in a sec.
Yeah, so you could. No, the court reporter wanted.
Hey, Smart. Hey.
All right, the nonstop fun continues. Let's proceed. We have three witnesses remaining, or not three witnesses, but three parties: Harford County, People's Council, and staff in that order. So let's begin with Harford County. Mr. Giel, correct?
Yes, that is correct, sir.
Okay.
As a preliminary matter, I would request before we bring the witnesses up, I'd like to solicit some additional testimony from them, particularly in regards to rebuttal testimony provided earlier. I just want to understand if that's permissible or not.
I didn't understand your question.
I have some additional testimony, direct testimony from my witnesses that was not presented in their direct testimony sheets, largely related to rebuttal testimony and certain comments made for the first instance at that rebuttal testimony. Normally, we just incorporate the direct testimony.
Right.
I'm just determining as a threshold matter if we should proceed with the additional questions or not.
All right. Do you care to comment?
Yes, Mr. Chairman and Commissioners, good morning. Carville Collins for Cardinal Energy Storage. Just to be clear and for the record, Cardinal Energy Storage did not oppose the intervention of Harford County in this case. In fact, welcomes the input and welcomes hearing the concerns of the county. When the Commission granted the petition to intervene from Harford County, and in accordance with the common and usual practice here before the Commission, the new entrant, the intervener, takes the case as they find it. Their late entry did allow them to prepare and submit testimony in a final round, in the rebuttal round. But I think what I hear the council from Harford County asking for is an additional round of testimony. That may not be necessarily something that we would oppose, except that this would appear to be asking for something that none of the other parties were afforded in this case. So I have concerns, but again, I don't want to oppose input from the county, but I do think from a procedural standpoint that this involves, based on my review of the exhibits and what we have heard this morning, that this is a new round of testimony, and for that reason, we would have reservations about it, Mr. Chairman.
I'm gonna allow the inclusion. We'll give it the weight it deserves. I'll permit you to do that.
And I'll note as a general proffer, this is mostly related to discussions of maps, and so we'd like to call our first witness, Brian Leitner, to the stand. Yeah.
Do you solemnly swear to tell the whole truth, nothing but the truth, so help you God?
Spell and tell us your name and spell it, and tell us what your place of employment is.
Yeah, my name is Brian Leitner, Bryan Lightner. I'm the Deputy Director for Harford County's Department of Planning and Zoning. Our business address is located at 220 South Main Street in Bel Air, Maryland.
Okay, thank you.
Thank you, sir. I have before you, slightly before you to your left, what I'm referring to as Exhibit 1. It's the testimony of Matthew Kropp. Are you familiar with this?
Yes, sir.
And you are not Matthew Kropp, is that correct?
I am not Matthew Kropp. I am the Deputy Director. He is the Director.
So you would accede to the testimony that was presented in this document?
Yes, sir.
To your understanding, it was prepared by Mr. Kropp?
Yes.
Do you believe, based on the review of this, that all the testimony presented therein were true and accurate at the time of submission?
Yes.
Do you believe that if we were to ask you the same questions today, that you would make any alterations to that testimony?
No.
Would you like to provide any additional updates to that testimony today?
No.
I'm going to ask you some additional questions for more testimony.
I mean, yes.
Yeah. I'm going to ask you some additional questions. Since it's not presented in that document, could you please present for the Commission your own professional history?
Yeah, so I have my bachelor's degree in applied geography from Kutztown University. About 20 years of planning experience working for both Harford County, Maryland and Cecil County, Maryland, and the tiny town of Charlestown in Cecil County.
I'm going to present to you a series of maps. Give me a moment, computer. I want to make sure I present them in the right order.
If you want to approach bench, go ahead.
I'm presenting these all at once so we don't just move around. They're in order of the numbers that we presented yesterday.
Are these the same maps that you
Yes.
sent to us electronically?
Yes, these are just physical copies of them, so Berlin has a larger version available.
Thank you. No, he's got more coming. He's got more coming.
Thank you.
Any other council or other physical copies?
Thank you.
I only have 2 more copies. These are, again, direct copies of the digital versions we submitted to you.
Mr. Chairman, for the record, I would just like to note our objection to these written exhibits that have been distributed for the same reasons mentioned. All of the other exhibits in this case to date have been materials from the case, either testimony or data responses. This is different material, and on that basis, we would object to the admission of this information in these handouts.
My response to that simply is all of these documents are county maps. They're public materials as opposed to editorialized maps. We're using them as a visual aid. Our witness can, of course, testify to his understanding of the county without these maps. If the commission doesn't want to include them, we're just using them for the purpose of permitting the additional visual aid.
I'll allow it. Objection overruled.
At this time, I would move, just to make sure that my notes are in order, Exhibit 1 for the testimony of Matt Croppent evidence.
So marked and without objection, so entered.
The exhibits presented before you, sir, are identified as Exhibits 3, 4, 5, and 6. Are you familiar with these maps, sir?
Yes, sir.
Did you compile these maps, sir,
I did not, but staff in my department did.
under your supervision?
Yes.
Could you please describe to the county the fabric of Harford County, not county, sorry, to the commission, the fabric of Harford County on a map-by-map basis, going with Exhibit 3 first?
Did you say fabric?
Yeah, the land use fabric.
Okay, sorry. Okay, never heard that term before.
And if it's all right, if I have these 4 maps at my disposal, I would start with the land use map.
This is Exhibit 3.
Is that Exhibit 3? Okay. Back in 2016, Harford County updated its master plan, and in doing so, establishes land use designations for the county. And of primary importance, I think, for our consideration today is what's considered a priority funding area in the state of Maryland. Opens up funding sources for higher intensity growth, both commercial, residential, industrial. It's what we call in Harford County the inverted T, and it connects the 3 towns, Bel Air, Aberdeen, and Havre de Grace, also within our jurisdiction. But the remainder of Harford County, you'll see in the sort of mint green color, is agricultural. And interspersed in some of our agricultural areas are historical rural villages with very minor commercial and institutional development.
And could you describe Exhibit 4 for us, please? This is the other preservation map.
So, very much related to our county's agricultural designation is what's sort of the inverse of a priority funding area for growth and higher intensity growth, is what's called a priority preservation area. It is where state and federal funding sources and county are focused to preserve active agriculture and prime agricultural soils.
And where is the oyster catcher Bess facility proposed to be located relative to these maps?
So unfortunately, it's located in our priority preservation area. It's the northwestern section of the county. It's kind of hard to make out on this map, but it's it's just about a mile as the crow flies southeast of the tiniest of our rural villages, Norrisville.
And how far away is it from the Pennsylvania border, roughly?
I'd say approximately 3 miles.
And how far away is it roughly from Bel Air?
I'd say about 15 to 20 miles.
So the cited location is substantially distant from any of the urbanized areas of Harford County.
That's correct.
Can you provide a general overview of the land use fabric in Harford County?
Yeah, if I guess go back to Exhibit 3. Just in general, again, higher intensity growth is focused in our priority funding area. These land use designations dovetail very nicely with our zoning district maps, which are the more detailed regulatory controls for development. In agricultural areas, predominant land use intent is agriculture or forestry activities, and very minimal commercial activity that is in support of agriculture.
Are you familiar with the site proposed for the oyster catcher Bess?
Yes.
Could you please identify Exhibit 5 for us?
Is that the...
That's the topographical map.
Yeah. So I've reviewed the preliminary layout proposed for the battery energy storage facility. And relative to just, the property boundary, taking into account its acreage, understanding that there's a headwater stream that bisects the property almost in half, running north-south. And you can see there are definitely some steep slopes that are proposed, at least with the preliminary layout, that would cause some concerns for development and potential erosion issues that
Where does that
follow.
headwater stream flow into?
Deer Creek.
Could you please present, let me strike that. Could you look at Exhibit 6, please? That's the intake maps.
Mr. Gill, before I look at that, I just wanted to point out
Well, sure.
on this exhibit,
We're going to come back to that's all right. All right.
Well-
Good, please continue.
there's the headwater stream that flows through the basic center of the property, but just to the southwest
Yes.
of the parcel, there's another headwater stream that also flows into Deer Creek. It's off the property.
And could you take a moment to explain Exhibit 6 for the commission?
Yes, so this is zoomed out, does not show the topography. Page 1 is just the property boundary. And look, BGE easements to the north. And then page 2 is the public water, public drinking water intake along further downstream along Deer Creek. And then page 3 is just, as the crow flies, distance from the proposed battery energy storage facility site and the intake along Deer Creek. It's about 20 miles.
And for confirmation, again, the headwater at the property flows into Deer Creek.
Correct. The headwaters that flows through the center of the property, as well as the other headwaters tributary to the southwest off the property, both flow into Deer Creek.
And there is additional steep drop-off from the southern end of the property down to Deer Creek. Is that correct?
Yeah, both the east side and the south side of the property have very steep slopes to contend with.
Could you please explain the local environment in northwestern Hartford?
Yeah, so it's very much rural. Again, there's the tiniest of our rural village, Norrisville, just about a mile to the northwest of the site. In the tiny rural village, there's a school and a fire station, and just a little bit more dense residential development. But otherwise, it's agriculture, it's big patches of forest, and a few single-family homes.
And could you please describe the Deer Creek watershed?
So the Deer Creek watershed's definitely a very special place to Harford County. In the state of Maryland, in terms of water quality, it ranks, last I checked, number 3 for highest of water quality in the state. We have native brook trout in the main stem, as well as some of the feeder streams that don't need stocking by DNR. They are surviving on their own. So from a planning and zoning perspective, we want to focus our efforts on protecting and preserving as much of the existing land use fabric in the Deer Creek watershed as we possibly can. The other deep tie, I'd say, it's really important for folks to understand in Harford County, is our community for over a century has also used Deer Creek as a recreational source of activities. Its a favorite pastime is to go tubing down Deer Creek from west to east in the county. So it is a beloved treasure.
Now, recognizing that citing these facilities is preempted by the PSC, which is why we're here today.
Correct.
In your mind, having reviewed these maps and in your experience as a planner for Harford County, do you believe that the project would otherwise be in comport with the smart growth planning scheme in the county?
No, it would not.
Why not?
Just referring to the topo map, I guess, is no matter what kind of development would be proposed on this site, with just looking at the preliminary layout, certain percentage of that parcel just I don't believe could feasibly be developed. I'm not an engineer, but I know that certain footprints of development need to do stormwater management. And given the steep slopes and the fact that stormwater facilities are designed to treat and control the volume of water associated with a 10-year storm, I know enough about climate change these days that we're experiencing more frequency of storms that are over that 10-year storm threshold. And so I have major reservations about the facilities being able to handle storms. and limit both erosion and pollutants from getting into the nearby tributaries.
And with reference to Exhibit 3, would you agree that the way that the Harford County zoning map is designed tries to limit or cite industrial activity to the south of the county?
Yeah, I'd say really all development activity. I mean, for decades, we've been planning smart growth in Harford County in accordance with state of Maryland laws. Just an recent example, in 2012, the General Assembly passed legislation related to the tier maps, and basically certain size subdivisions were limited in tier 4s, tier 4 designated areas to be treated with private on-site septic systems. So even residential development has been curtailed, I'd say, in the past 10, 15 years in more rural areas. And certainly, again, in keeping with priority funding areas and just decades of local economic development, steering incentives towards development within the what we call the development envelope, our priority funding area. They're synonymous. That's where we want to see industrial and commercial development of higher intensities focused.
And is there any public water or sewerage up near where the proposed oyster catcher facility would be?
No,
Is there any real feasible capacity to bring public water and sewer up there?
no.
Have you had the opportunity to review the submitted written testimonies of Mr. Latham and listen to his testimony yesterday?
Yes.
Do you believe that the commission should evaluate any environmental or zoning impacts after it's decided to approve ESCCs or before?
I believe before. I hope before.
Do you know of any time that the applicant had been able to get in contact with any member of DPZ?
No.
You reviewed the testimony that stated that there were attempts reached out to DPZ in late April and middle of May of 2026?
Yes.
And you don't have any records from any emails or phone calls from any attorneys?
I do not.
Have you ever received any information about meetings with Karen Holt or Joe Cluster with regards to the proposed facility?
I have not.
You heard testimony from Mr. Latham in his rebuttal testimony and repeated in testimony and cross-examination yesterday that he believes the project is permitted by right in the agricultural land use zone. Do you recall that testimony?
Yes.
Do you believe that that is correct?
No.
Again, when you approach the bench, you should ask for permission.
I'm sorry, sir. Permission to approach the witness.
Yes.
I apologize.
Thank you. Good.
At this time, I'd like to move Exhibits 3 through 6 into evidence.
So marked and without objections.
There is an objection, Your Honor,
Oh,
Yeah.
for the reasons mentioned. I won't belabor the point.
yeah. Yeah, I'll allow it.
I have before you exhibit, what's marked as Exhibit 7.
Pardon me,
Excuse me.
Commissioner Linton.
Yeah, thank you, Mr. Chairman. Is this, which exhibit number is this?
This is Exhibit 7.
Okay. Thank you.
So entered.
What is Exhibit 7, sir?
I'm sorry?
What is Exhibit 7?
So,
Yes,
Oh, sorry.
yeah, I don't know.
so this is our permitted use chart found within our zoning ordinance.
And this, you don't know of any recent changes to this use chart?
No, sir.
This has been the standard use chart in Harford County for a period of years,
Yep.
since at least its last zoning rewrite.
You got it, since 2024, last
And
amendment.
before 2024, are you familiar with any major changes that occurred to the types of uses that were allowed on the zoning, sorry, in the zoning ordinance?
No major changes, no.
The particular use that the applicant's witness cited as the reason for why he believed that this project was allowed by right was we'll turn to the second to last page, public utility facilities, sanitary landfills and sewage treatment plants, which he identified as being permitted by right in all districts other than MO. Do you recall that testimony?
Yes,
Do you believe that this facility, if it were reviewed by Harford County, would be categorized as a public utility facility?
no,
Do you believe personally that there is any identifiable use category in Harford County that would allow this type of facility?
no.
If a facility doesn't have an appropriate use category, what is the county's legal position with regards to whether or not that use is permitted or not?
We try to find something materially similar already in the ordinance. If we don't, we look at the NAICS tables for reference. And that's the process.
If you can't find anything, would it be prohibited?
Correct.
If you were to review this, what sort of use do you believe you might be able to categorize it in as any, if any?
Yeah, there isn't one. If I had, if you were twisting my arm and I had to choose, I'd say power and regeneration plant.
And that use would be only allowed in GI?
Correct.
Do you have any information that you're aware of regarding any communications with BGE and interconnectivity between Conestone and the oyster catcher facility?
I do know that BGE has concerns granting an access easement to the property across their easement.
On the basis of presently submitted materials, do you believe that the PSC should provide ESCCs to the oyster catcher proposal at this time?
No.
I'd like to move Exhibit 7 into evidence, and that concludes my direct.
Yeah, I admitted it.
Sorry, we didn't.
This?
Yes, we didn't move that into evidence yet. That was
Okay, well,
6.
okay, so admitted.
Thank you.
We note our objection, Mr. Chairman.
Right.
I have no further questions.
Okay, let's go to cross-examination. RWE Supply,
No questions for this witness, Your Honor.
Cardinal Energy.
Yes, Mr. Chairman, thank you, and I do have a few questions. Good morning, Mr. Leitner.
Good morning.
I'm Carville Collins, representing Cardinal Energy Storage. Nice to see you. Let me begin with your testimony here today. I think I understood you to say that the proposed oyster catcher facility, in your view, does not comport with the smart growth policy of the county. Is that correct?
Correct.
And I think you also testified that what the county has been doing is tried to limit all commercial development to the so-called development envelope in the county. Is that correct?
I'd not say all. Higher intensity commercial development, lesser intense commercial development that supports agriculture outside.
And so on the map, which is Harford County Exhibit 3, the land use map, which is the colored map, think I understand the development envelope to mean the areas that are not in green. Is that correct?
Correct. Yeah, and I'd qualify that. Dark green is for parks, so there's some of those in the development envelope. Mint green is the agricultural area.
Understood. Thank you. Thanks for that clarification.
Yep.
Are there public utility facilities in any of the green areas indicated in the land use map that you're aware of?
Mint green, yes. Yep. Such as the Conestone substation.
Yeah, and perhaps other substations of the local distribution utility, Grayston and other areas in the green zone of this map. Do they exist as well?
Yes, sir.
And in addition, transmission lines, are they located in this green zone?
Yes.
And I think I understood you to also indicate that in your testimony here today that the proposed oyster catcher project, in your view, is not permitted by right. Is that correct?
That's correct.
And I gather that your conclusion would be that, therefore, the proposed oyster catcher project does not qualify as a public utility facility?
Correct.
I wonder if I could ask you about the definition of public utility facility in the zoning code. I'm going to read it to you as I understand it, and please correct me if I've misstated it or understated it or overstated it.
And counsel, I don't have it in front of me, so.
Understood. It's a short definition.
Okay.
So I think we can all manage. It's defined as a utility facility owned by a governmental agency or private organization, maintained and operated for the benefit of the general public, but excluding highway maintenance facilities, sewage treatment plants, sewage pumping stations, and solid waste transfer stations. Does that sound correct in your view as to the definition?
It does.
Now, there's also a definition in the code for public utilities, and I won't read that one to you because my client, the proposed developer here, they're not a public utility. Public utilities tends to refer to companies such as BGE. But my client, Cardinal Energy Storage, is a private organization, and this is a utility facility. So how is it that my client does not qualify, and its proposed project does not qualify as a public utility facility in your view?
Counsel, could you repeat that second sort of part after it says public and private?
Yes. A utility facility owned by a governmental agency or private organization, maintained and operated for the benefit of the general public.
I think that's where we have our difference of interpretation. Maintained and operated for the general public. I'd say our department doesn't have enough information to verify that.
Is it your opinion that this proposed facility provides any benefit, or is there any benefit to the general public from a facility such as this? Just based on the plain words of the definition.
Just based on the definition?
Yeah.
I don't know. I don't have enough information.
I think I understood you to say that the proposed oyster catcher facility would not qualify as a public utility facility. Instead, it would be considered to be in a category called power and regeneration. Is that correct?
I'd clarify that there is no materially similar use in our current zoning ordinance, and so it's prohibited. If I went outside of the bounds of the zoning ordinance for a second and had my arm twisted and said, you have to pick one, that's the closest I could come up with is power and regeneration. Yes, sir.
In Harford County Exhibit 7, which is the permitted uses chart, could you help point out to me and to the commission where that power and regeneration classification is noted?
Yeah, it's the second to the last page. Under transportation, communication, and utilities. Fourth one up from the bottom in the list. It's permitted in the what's called the general industrial zoning district.
Yeah.
And so by assigning this particular use classification, if you were forced to classify it, you'd consider this to be a power plant or a regeneration plant?
That's correct.
Now, in your testimony, you also mentioned, I believe, that you knew of no time where there was an attempt to meet with the Department of Planning and Zoning.
Correct.
Yet in Mr. Latham's testimony, your counsel asked you about that specifically, and you said, despite what was in Mr. Latham's testimony, you know of no time in which the applicant or its counsel made any request for a meeting, correct?
Correct.
Mr. Chairman, and may I approach the bench?
Yes.
I have an exhibit. I have handed you a copy of an email exchange that occurred as early as April 28th and as late as May 12th. Do you see that?
Yes.
No objection, by the way.
No objection.
No objection.
Well, yeah. Yeah.
Haven't moved it into evidence yet.
Good heads up, though.
But let me just ask a few questions first. Yeah. Based on the first entry there below my name, could you just indicate as to the May 12th email, Tuesday, May 12th, 2026, who that's from and who that is directed to in the county?
Yeah, it looks like it's from my director, Matt Kropp, to Mandy Heinel with Saul Ewing.
And the earlier email, which is below, could you please explain to the commission what that is? The one dated Monday, May 11th.
Looks like Mandy Heinel from Saul Ewing emailing my director, Matt Crop.
And below that, which is at the bottom of page 1 and the top of page 2, would you agree that there Ms. Heinel is circling back to see if we can find a time to meet? Would you agree?
Yes.
And then the earliest email, Tuesday, April 28th, could you just summarize for the commission who's that's from and who that's directed to and what the content of that request is?
Yeah, that's Mandy Heinel from Saul Ewing reaching out to my director, Matt Crop.
And that was April 28th, correct?
Yes, sir.
Now, in this email, it does indicate that Mr. Kropp, on May 12th, he indicated to Ms. Heinel that he did not have time to meet on a particular day. Please send information by email. That may work better. Do you see that?
Yes.
And I think I just want to explain to you that we understand that there's a lot going on and there is many responsibilities of your office. So we're not suggesting here that on this one it was a refusal to meet. It was just that he was not available. Would it surprise you that after this email exchange, Ms. Heinel then made some telephonic requests to Mr. Kropp's office asking for meeting dates? I mean, you may not have any knowledge of that, but would it surprise you if that occurred?
No.
Okay. Mr. Chairman, I have no further questions. Thank you.
Okay, next would be Rev Renewables. Oh, yeah, right. Yeah, I think you may have forgotten to mark and submit this.
Thank you. I'd like to mark this as Cardinal Energy Storage Exhibit number 5. And if there are no objections, please move it into the record.
So marked and without objection, so entered. Okay, Rev Renewables.
No questions for this witness, Your Honor.
Chalk Point.
Chalk Point has no questions for this witness.
Anybody here from MEA? Okay. People's Council.
We have no questions, Your Honor.
Okay. Sierra Club.
We have no questions.
No questions?
No questions.
Okay. And staff.
Yeah, just one or two questions. Good morning. So, if a land user comes to the department with a proposed land use, who is it that would make a designation as to what classification it falls under?
It depends on the alignment with the use and our permitted use chart. Sometimes we meet as a committee if the use doesn't fit neatly within the chart. As you can imagine, things in life don't always line up neatly with that chart. I'd say if there's a certain confidence level that there's a match or an interpretation, lower level planning staff can make that determination. But if it's trickier, more challenging to make a confident interpretation, it could bubble up to myself and the director level to make that determination.
And I think you had mentioned that sometimes a committee would consider it.
Yeah, a committee that meets weekly.
Okay. Now, in a situation like this, where it sounds like it doesn't fit so neatly in that a lower level staffer would perhaps make the determination, just to clarify, would the determination likely be made by you or Mr. Krupp, is it?
Yes.
Or would it perhaps go to the committee?
Well, it would go to the committee
It would go to the committee.
first.
Okay.
Yeah. Yep. If there's ever any hesitancy, I'd say in confidence level of lower level planning staff, it goes to the committee. We meet weekly. Challenges are discussed and vetted there.
Okay. And if a proposed land use, or a entity or a facility that comes to you for permitting, if they do not agree with the designation that they receive, or the classification that you determine, is there a way to challenge that determination?
Yes.
How does that work?
Yeah, so from our director, a written request for what's called a determination of a use and whether it's permitted in a certain zone.
Okay. I think I only have one more question. In this use classification chart, when there's a blank cell indicating that the use is not permitted, such as the power and regeneration plant within the agricultural zone, is it not permitted in all cases, or is there a process by which you can look for an exemption? Or
So that written use determination, once received by the applicant requesting, that can be appealed to our Board of Appeals, which is our county council.
okay, and then
So-
they could override it, basically.
Correct.
Okay.
Yep.
Okay, that's all my questions.
All right. Redirect?
A few questions, sir. First, with regards to the questioning from the applicant, you were presented with Exhibit 5. For clarity, you never were CC'd in any of these communications personally,
No.
but this does appear to be an authentic email communication between Saul Ewing and, Saul Ewing's attorney and Matt Crow.
Yes.
Does the email chain at any point identify anything other than that there is a project in Harford County?
No, it does not.
If you were to have tried to search through your email history in order to find any possible communications with regards to this facility, would there have been any identifying information in the emails that would have allowed you to know that they were talking about this facility?
No.
And there is no subsequent communication after May 12th with Matt Kropp's response?
Not that's been provided, no.
So, while there does appear to have been some sort of attempt to reach out to DPZ, this communication wouldn't have allowed you to recognize that that they were talking about this approval. Is that correct?
That's correct.
And with regards to staff's question about the classification charts in the zoning use table, for clarity, if there is a use that might require a conditional use special exception type deal as opposed to being prohibited outright, would that be identified in the zoning chart in any way?
Yes, sir. It would be identified with an SE.
And that's identified in the key at the top of all the pages?
Mm-hmm.
So if there were a special exception approval for something like a power plant in agricultural, it would be marked with SE.
Yes, it would.
Thank you. I have no further regret.
All right, we'll go to questions from the bench. We'll start with Commissioner McLean, then Linton, then Suchman, then Hoover, then the chair in that order. Commissioner McLean.
No questions, sir.
Commissioner Linton.
Thank you, Mr. Chairman. I just have a couple questions. Good morning.
was that regeneration thing?
I'm not sure which of the maps you could direct me to, but I'll ask the question generally first. Is it your understanding that the proposed oyster catcher BESS is located on the Cornerstone substation property?
No, it's my understanding it's adjacent to the Conestone property. It's on a separate parcel.
Completely separate parcel.
Yes, sir.
Okay, so where on the maps that you
Maybe.
are we able to show me on these maps?
Yeah, I think it's page 3 of the, or sorry, page 1 of the 3
This one?
page
Let
map.
the record note that it's Exhibit 6.
Exhibits. Okay.
Yeah, it's
Thank
the
you.
first page of Exhibit 6. I think you can see oyster catcher parcel proposed on land that's highlighted in yellow. And then just to the north is up on the map. Just to the north is BGE easements. And then to the north of that is the substation property.
Okay. So this property that the oyster catcher is proposed to sit on is currently not part of the Cornerstone substation. It's not owned by BGE or fenced in as part of their substation property.
That's correct.
Okay. And this same area is currently used for, I think you testified earlier that it was used for various recreation and other types of,
This map shows it pretty well. The headwater type tributaries that drain down into the Deer Creek. So it's the main stem of the Deer Creek primarily that's such a significant recreational resource for our community.
okay, I apologize for asking. I've never been over here, so I'm just trying to understand, trying to see in my mind where this area is, but, okay. All right, thank you. So my other question is regarding Mr. Kropp's direct testimonies on lines 13 through 16, where Mr. Kropp suggests that should the PSC approve the project, he lists 2 specific conditions that he would like to see incorporated into it. You've heard the testimony of one witness from the applicant. Do you believe these issues either have been addressed already, or are you encouraged that through working with them, these conditions could be addressed?
So, Commissioner Linton, I want to make sure I'm looking at the right spot. Is it page 6, lines
Yes,
13 through 16?
Yes,
Okay.
page 6, lines 13 through 16, direct testimony.
Right.
Well, it starts on page 12, line 12.
Yeah. And I guess I'll try to highlight what those 2 conditions appear to be. 1, downscaled appropriately, and 2, constructed with full containment measures to prevent releases of materials or chemicals to the environment.
Right.
So I'm sorry.
So
Was there a question about those 2
Yeah,
conditions?
You've heard their testimony from, it was yesterday, their witness testified, and they did express a willingness to meet, continue trying to meet with the county and address some of your concerns. Mr. Kropp doesn't say what he means by downscaled appropriately, but I guess I'll start at the high level. Do you think that through the testimony you saw yesterday, is the county interested, willing? Do you believe that you can reach an understanding or at least an acceptance of certain conditions along these lines with this project?
So no, I feel pretty strongly that we're far apart based on everything I've heard so far.
Okay. Are you able to just on a high level at least, explain what Mr. Kropp meant by downscaled appropriately?
I think just looking at the preliminary layout, that's been proposed. From our perspective, in terms of just development footprint, limit of disturbance on the ground, tree clearing, it's a high percentage of the parcel. So downscaling, I believe, would be reducing the limit of disturbance and really the number of battery storage units on the property.
So it was less about the capacity of it and just more about how much space it was taking.
Correct.
Okay. Okay. All right. Thank you. Thank you, Mr. Chairman. That's all I had.
Commissioner Suchman.
Good morning, Mr. Leitner.
Good morning.
Okay, so let's go to Exhibit 6. And it looks like Deer Creek is smack in the middle of the project property. Is that correct?
A headwaters tributary to Deer Creek is smack in the middle of the
Okay.
property. Yes,
Okay.
ma'am.
So headwaters, meaning that this is where it starts.
You got it.
Okay.
And there may be springs associated with the
Okay,
area.
but it starts there, and then it flows south? Okay.
Yes.
And then it's used for drinking water?
Yeah, there's an intake 20 miles to the southeast that is drinking water for Baltimore County, a source for Baltimore County, Harford County, cities of Aberdeen and Havre de Grace. And if you follow Deer Creek to where it empties into the Susquehanna River, on the other side of the river, the town of Perryville and Cecil County. But yeah,
Okay.
Yeah.
And then in terms of Harford County population, what does that represent in terms of sort of percent of residents within Harford County? Are we talking about a lot of residents that are relying on the Deer Creek watershed for drinking water?
I wish I knew the answer, Commissioner Schuman. What percentage of the drinking water that is treated for a certain percentage of residents in the county originates from Deer Creek? I don't know.
Okay, but there are certainly residents that are relying on the Deer Creek watershed for, and then do you know what would happen? I mean, we heard yesterday testimony about the fact that it's like almost impossible for any of the batteries to leak into the watershed. Being a lawyer, I've been faced with people who have told me in my work history that was impossible, and yet the possible happened. So I guess I'm just trying to get a sense of the risk of if there was leakage into the headwaters of Deer Creek. It is your understanding that would contaminate the water and put at risk all those who are relying on it for drinking water purposes?
That's correct.
Okay.
And
So if this is the headwater, and if we look north to the Conestone substation, it's also blue. What does the blue represent there? Do you know?
yeah, so in some cases our hydrology information, it can show, as I believe to be the case exactly here, drainage swales. And in most cases, site drainage do tend to try to mimic hydrology.
Okay.
So that's why it's connected there from a stormwater management perspective, which we're responsible for in our Department of Public Works.
Okay, and is
That's
that
why it's
is
also
that
blue.
flowing into
Yes.
the Deerwood? Okay.
Yes,
Okay.
it appears to be connected. Yes, ma'am.
Okay. So from the substation, there's the possibility of contamination as well.
Yes.
Okay. And there's also Greyston substation that's east of Conestone. Do you know if that's in a watershed?
In the Deer Creek watershed?
Well, or in any watershed.
It is in a watershed. Yes, ma'am.
Okay.
Yep.
I'm assuming that these are relatively old substations. Perhaps they were not as sensitive to stormwater contamination affecting the watershed. But
Yeah.
perhaps we know more now.
I
than
think we do, and I'll elaborate maybe just a little bit on just source water protection, drinking water protection. When we have surface water intakes, we're absolutely looking at watersheds and what's called, I think in the sort of professional term, potential sources of contamination. And usually rule number one, if you have that sort of land use control, is to not allow that use to begin operating in the first place. Because once you have it, you're constantly looking to mitigate, you're monitoring, and if necessary, mitigate. And ultimately, if you don't mitigate, you are treating at your drinking water plant, which
So
has
I'm
costs as well.
right. I'm assuming you'd be open to having a conversation with them that would not put the watershed at risk.
So, going back to Commissioner Linton's pointing out in Matt Kropp's direct testimony, line 15 and 16 on page 6, it's, if it's possible to construct with full containment measures to prevent releases of materials or chemicals to the environment, in my professional experience, when there's a requirement for a stormwater facility to not just treat but to control the 10-year storm event, and when just common sense, and I guess from my professional experience it's not just common sense, we know that there's more frequent and intense storms than 10-year storms these days. What measure could there possibly be to guarantee 100% containment? And it's just, there's not enough information today.
Right. Okay. That's all I have. Thank you.
Commissioner Hoover.
So if you could turn to the land use map that you referenced earlier.
That's Exhibit 3 for the record.
What?
Exhibit 3 for the record, just
Yeah,
for the stenographer.
So is it the county's position that if this facility was proposed to be located in which you refer to as the priority funding areas, the sort of non-mint green areas, that the county's objection would go away?
I still go back to our interpretation that it is a battery energy storage facility today is a prohibited use. It's not listed in our chart. We can't find anything materially similar.
So what you're saying is, under your current zoning regulations, this thing can't be located anywhere in Harford County?
Correct.
Okay, fair enough. Thanks.
A lot of my questions have been answered, but let me just, if I'm remembering from your testimony, I think you were rather emphatic that, no, let me say it this way. You don't believe that there's any legal basis for doing this kind of a facility in your ag reserve zone. I think I heard you say something like that.
Well, and I believe Harford County's council touched on this. We recognize the state's preemption of local zoning. I don't know enough legally about how this facility could be interconnected to a transmission line to know if it falls under that preemption or not.
Okay. Are you familiar at all with the Next-Gen Energy Act that was passed in 2025?
A little bit familiar, yes, sir.
Okay. Because, when it comes to legality, we're going to be guided by the state law. Let me ask a question about substations, generally speaking. So you recognize substations as being, and the county recognize substations as being a utility function,
Yes.
but not electric power regeneration.
Correct.
Okay. And I think Commissioner Hoover asked my question. My last question is going to be, so you're basically saying that facilities like these should be located in places like Bel Air, Havre de Grace, places like that.
Right. I said it's currently it's a prohibited use anywhere in Harford County.
Okay. All right. I don't have any more questions. Thank you very much for your testimony. Please call your next witness.
Thank you, sir. We'll call Thomas Shake to the stand.
Thank you. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
And please state your name and spell it for the court reporter.
Good morning. My name is Thomas Scheck, S-C-H-A-E-C-H.
And please tell us your position and your place of employment.
Okay. My position is I'm the president of the Harford County Fire Service. We have an all-volunteer fire service. I represent all 11 volunteer fire companies and one EMS company within the confines of Harford County. I answer directly to the county executive and the director of administration on fire service issues.
Okay, thank you.
Permission to approach the witness stand.
Granted.
Before you is direct submitted testimony that I am referring to as Exhibit 2. Are you familiar with this testimony?
I am,
Was this prepared by you or under your supervision?
by myself.
Were your responses true and accurate at the time of submission?
They were.
If I asked you the questions today, would they be the same?
Yes, they would.
But do you have any additional comments that you'd like to make at this proceeding?
I submitted additional testimony via email to council following the review of rebuttal testimony by Mr. Latham.
Could you please provide some additional detail to the commission for your professional background?
I have 51 years in the fire service. I started in 1976 in Harford County. I've continued my service there since then. I have 34 years of experience as a career fire officer with the Baltimore County Fire Department. I retired in 2013. I have extensive education and experience in not only fire suppression and management, but emergency management, emergency medical services, to include instructional level at the state of Maryland. I was co-chair of the Baltimore Metropolitan Fire Chiefs from 2005 to 2007.
Before we get away from it, I'd like to move Exhibit 2 into evidence.
So marked, and is there an objection?
No objection if we're talking about his written testimony.
We're talking about his written testimony.
That was submitted last week?
Yes.
No objection.
Okay, so admitted.
Are you familiar with the Kona Stone location where Oyster Catcher Best is proposed?
Yes, sir, I am.
Have you personally visited there before?
Yes, I have, as late as this past Monday.
Do you foresee any issues with this project as it relates to immediate on-site or off-site impacts?
Yes, I do. The site in question is served by a lone county-maintained and owned road, Jolly Acres Road. Jolly Acres Road traverses both the northeastern portion of Baltimore County and enters off of the northwestern portion of Harford County. One of the primary access routes would be for fire service units responding to a potential incident at that facility would be entering off of Maryland Route 439, otherwise known as Old York Road in Baltimore County. That stretch of Jolly Acres Road is mostly a gravel road, about 20 to 22 feet in width. It is narrowly navigated by one vehicle, almost impossible to navigate with two vehicles.
And this gravel road system and the width is therefore an impediment to emergency management of any disasters in the area?
As it currently exists, yes.
Do you believe that it's possible for emergency facilities to access this area at the speed and intensity needed to contain an emergency scenario?
I do have reservations just by the sheer design and nature of those roadways in that general area of the county. Those roads were not designed to handle the average weight of an emergency vehicle on a repeated basis. Isolated cases for a simple dwelling fire, yes. On a repeated basis, such as an incident of this nature in this area, no.
Do you believe that this project is appropriately sized relative to the location?
With respect to the fire service, and I can obviously only speak to fire service responses, we have concerns about the size of the project.
Are you aware of any present or future plans to expand emergency service facilities outward to this location?
There are no plans at this point.
Mr. Chairman, I'm going to object at this point to this exchange of information. Much of the testimony that is just being given here today is very similar to the written testimony that Mr. Sheikh has already presented and submitted in this case. I'm not challenging the content of the testimony, but this does feel like another round of testimony. None of the other parties in this case have been afforded that opportunity. So I just want, for the record, to note our objection.
Your response?
Well, I can move ahead with some of the questions to focus more on the stuff that was in rebuttal testimony. So if that pleases opposing counsel, we'll move ahead with some of the questions.
And that was in the rebuttal testimony, that rebuttal testimony has already been submitted and is before the commission. So this feels like a further round of testimony that none of the other parties have been afforded.
It does. Try not to be repetitive of the testimony that's already been filed.
If you'll permit me a moment to curtail any additional questions in line with the chair's directive. Is it not working? Thank you. I'm ready to proceed.
Please proceed.
Do you agree with Mr. Latham's testimony in his rebuttal and in the cross-examination yesterday that the lack of water supply in the local environment is not expected to be an issue?
I do not agree.
Why do you believe that's incorrect?
The fire service is not an exact science. It is more of an art. No two incidents are approached in exactly the same manner. I cannot, nor can anyone, predict the type of scenario that would confront a first arriving chief or command level officer or engine company when they arrive on the scene of a reported working incident. Working incident defined as one where actually we have flame and smoke showing. Although current data from industry experts, consensus standards from the National Fire Protection Association discuss the limitations of water application to a fire incident given of this nature. However, there are surrounding issues that we call in the business exposures that require cooling water in volumes that would greatly exceed what is carried on first arriving apparatus to an incident of this nature.
Is this comment correct that the best practice with battery fires is to conduct an observed controlled burnout and only provide cooling water to adjacent containers?
Again, it would depend on the exact incident that we were confronted with upon arrival and assessment by the command officer.
Do you foresee any consequences to local air, ground, and water resources in the event of a controlled burn containment?
Absolutely. The area in question is devoid of municipal water supplies. Static water supplies, which we identify as ponds, accessible streams by motor pump fire apparatus and so forth, are at a significant distance from being able to safely and adequately place a piece of pumping apparatus to draft water, pull water in a vacuum from one of those sources, load it into a tanker truck, and have that tanker truck transport that water over, in often cases, many miles back to the incident scene. This all takes time to set up. It takes time and logistical coordination to maintain, especially over a prolonged period.
Do you agree with this claim that the project, quote, would not exacerbate the need for heavy fire trucks to traverse the roads?
I disagree.
Why so?
Even if something as mundane as an automatic fire alarm, a perimeter alarm, whatever you want to call it, is set off at the facility, it requires the response of at least one major piece of apparatus. We call a major piece of apparatus an engine company or a ladder truck. The gross vehicle weight of an engine company right now is around 60,000 pounds plus. A ladder truck is 85,000 pounds plus. The roads are not designed to take that sort of a continued beating.
Do you agree with the statement that no specialized firefighting materials would be needed?
Cannot comment to that because we don't know, again, what is involved. We have no safety data sheets. We have no idea of the materials to be presented on site. Again, this would all be hopefully part of an early on mutual pre-incident and hazard mitigation analysis planning profile with the local fire chief,
Which has not yet occurred.
which has not yet occurred to my knowledge.
And what would happen to local inhabitants in the event of a disaster scenario?
If we have a disaster scenario, and again, my business operates on a worst case scenario. We plan every day for worst case scenarios. We would have to look at hard two options. Shelter in place, which creates a problem of access be given the area and the limited ways of which we have to access these residents to provide them creature comforts should they not be able to move about as they normally would. If we have to move them, we own them. We have to find places to keep them, and in a case like this, if we have smoke, we have runoff, where we have, it's determined by local health agency that we have to maintain these people in a remote location, we have to care for all their creature comforts. And we have no idea how long that would be until it's rendered safe,
Or how costly it would be?
or how the cost would be. We have some rough estimates, but again, they are just rough estimates.
What are your thoughts regarding the proffered testimony that about the 3-mile distance of the Norrisville Fire Company and, quote, 8 other departments within 10 miles?
Those distances are, they may, and I don't know how those numbers were arrived at, whether it was by the crow flies, whether it was by strictly using Google Maps as road mileage and so forth. Some of those fire companies contain apparatus that is not suitable for a response of this nature. In a hypothetical scenario, given the incident location, you may have companies coming as far away as from Lancaster County, Pennsylvania, strictly because of the need for specialized large capacity tankers.
So this would potentially involve a multi-jurisdictional issue with Hartford, Baltimore, and even a different state.
Correct. Normal response to that corner of the county on a daily basis right now is 2 states and a minimum of 3 jurisdictions.
Do you have any concerns if the applicant were to reach out to the local emergency response agencies after it submitted and designed materially complete site plans?
Yes, I do. From an emergency management perspective, the best laid plans are the ones laid early, very early on.
The applicant's witness claims to have a record of substantial local community and stakeholder engagement. Have you seen any evidence of that in this case?
No, sir, I have not.
I have no further direct questions.
All right. Cross-examination, RWE Supply.
No questions, Your Honor.
Cardinal.
Mr. Chairman, I have no questions about the testimony, but I just want to acknowledge Mr. Shake's testimony and indicate that we agree with many of his observations, including planning early, and we will be doing that with you. We look forward to that. Thank you.
Rev Renewables.
No questions, Your Honor.
Chalk Point.
No questions, Your Honor.
Okay. MEA is not here. People's Council.
We have no questions.
Okay. Sierra Club.
We have no questions.
Okay. Staff.
No questions, sir.
We, well, no redirect then. We will go to the bench. We'll start with Commissioner Linton.
Thank you, Mr. Chairman. Good morning.
Good morning, sir.
I just have one question regarding Mr. Latham's testimony yesterday. Did you get a chance to hear it?
I did.
Okay. we were discussing the concept that you mentioned in your testimony as part of the larger report regarding the idea of burnout for the battery in the event of a catastrophic situation. And he suggested that the appropriate reaction would be to just let it burn out and not use water on it. I believe in your report you suggested that that was also the appropriate reaction, not necessarily favored, but the appropriate reaction. Is that appropriate? Is that correct?
Given the current technology that's available to the fire service, innovation is not caught up with any appropriate extinguishing or mitigation method to a direct fire attack on a said facility at this juncture. We look at several things. I would never rule out water on anything. However, only use an application of water in an instance where I felt, as the command level chief, that it would not exacerbate the incident and cause a worsening of the situation. We have a thing in the industry called exposure protection, surrounding structures, surrounding infrastructure that we may apply water to in an attempt to prevent further thermal runaway, overheating of componentry, natural cover, the grasslands, the trees, and so forth, protect them, or to prevent an ignition source from occurring there.
Okay. So what is the strategy or approach for the emissions that come from the burning out?
Again, and I believe in the rebuttal testimony from Mr. Latham, one of the things that was mentioned was air monitoring, and that there would be on-site facility fixed installation air monitoring devices. I can tell you right now the fire service will not, has not, by virtue of our training and our experience, we will not rely on facility offered, facility installed monitoring devices. This is not a slap at the industry. This is because time and time again through retrospective studies that these facility monitoring devices are inherently inaccurate. We would provide our own monitoring based upon our certification, our recertification of said devices that we are familiar with using and reading every day. We would make determinations on sheltering in place, evacuations, additional safety measures based upon the results obtained from our monitoring devices.
But that would be an acceptable way of mitigating those types of emissions if they were to occur.
Mitigation of an emission of that sort, and again, depending upon the size of the incident, if we arrive, and it's going to take a while to get there because every road, and I'll use the Norrisville Fire Station, which is indeed the closest station per Mr. Latham and my own knowledge, to that facility, they're going to be 9 to 10 minutes easily getting there, even on a day like today when the road conditions, the weather conditions are ideal. These incidents propagate very rapidly just due to the nature of the composition of the materials involved. We would, again, make those determinations on a case-by-case basis. I would not be foolish enough to sit here and make a generalized statement on how I would approach any given incident of this nature until I had the opportunity to provide, again, what the industry we call a 360-degree assessment survey of the incident at hand, and then make some judgments based upon that information.
Okay. Thank you very much.
Thank you, sir.
Mr. Chairman.
Commissioner Suchman.
Good morning, Mr. Shack.
Good morning.
Kudos in being involved in really important work for the last 50 years. So that's great.
Thank you.
I'm assuming in your 50 years of experience, you've seen sort of out of control or very large fire situations that have had an impact on the Deer Creek watershed.
Not specifically the Deer Creek watershed, but I have been a first responder on significant incidents that impacted the lives of residents. I was the first in on the Chase train derailment in January of 1987 and made assessments and size-ups as a first in person on that call. So I think I feel qualified to make those assessments and determination based upon that incident in of itself.
Okay. Mostly I'm trying to get a sense of whether you've seen after a fire's been put out, you've seen the impact of that fire on a watershed?
Yes, I have.
Okay.
Yes.
And can you sort of describe the challenges in addressing contamination, runoff, and how that has impacted the watershed?
Well, first of all, again, I go back to a previous statement. These incidents are not in the guide rails. Every incident is unique in and of itself because they are, by definition, uncontrolled. They are uncontrolled until we determine that the bulk of the expansion of the incident is well within our hands. Then we have to look at what occurred during the actual extinguishment or mitigation effort. How far did even our attempts at control, because things splash, things run downhill. We have the probability of inclement weather, which can play a part in the lack of being able to control something, if that makes sense. We cannot, by application of water, something as simple as that, we cannot control exactly where that runoff goes. So we have to make assumptions based upon the geography and what we know water does, contaminants do, whether they leach into the soil, whether they float above the soil and are transported directly to a known waterway.
Okay, and have you seen in your experience impacts that are felt weeks after an event, months after an event, perhaps even years after an event?
Absolutely.
Okay. All right, thank you.
Yes, ma'am.
Commissioner Hoover.
So this gravel road you described that leads to where the facility would go, who owns it?
A portion of it lies within Baltimore County, so it is a county-owned road. There's a portion within Harford County that we own.
Okay.
We being Harford County.
I understand. So, and is this the same road that you would take to go to the existing substations that are there?
Fire apparatus responding off of Maryland 439, otherwise known as Old York Road, would indeed approach from that direction. The initial fire company, or the first due fire company, which is Norrisville Volunteer Fire Company, they would come in off of a somewhat wider paved road, which is, again, Jolly Acres Road. They would come in off Maryland 23 or Norrisville Road. We would have apparatus coming from multiple directions.
So you currently, so if there was a fire at the substation, you'd have to take the gravel road to get there, right?
Yes.
Okay. Has there been any discussion within Harford County about possibly upgrading the road?
Not at this time.
Okay. All right, thanks.
Yes, sir.
Commissioner Linton? Linton,
No,
McLean, sorry. I get you guys mixed up all the time. Yeah, they look alike, yeah.
I have no questions, but thank you very much for your service, sir.
Thank you.
Okay, I have a number of questions. So you feel confident that you could put out a fire at a substation?
I do not.
Oh, okay. Do you feel confident that if a transmission line were to collapse and set a fire somewhere, what would your response be to that?
First of all, we're going to deem the safety of the responders and the surrounding community first. We will approach this incident and provide what we call isolate, deny entry until such time that, in the case of a transmission line or the substation, that the utility provider, in this case BG&E, would guarantee us through confirmed radio transmission that the power is shut off. Then and only then would we approach and put out any residual fire.
Interesting. Okay. Probably there are people living in your county who have behind the meter storage batteries like Tesla Powerwalls and the such. First question, have you had an incidence of any of them burning?
We have had some isolated incidents, not with storage batteries of that installation nature, but we have had a couple of incidents over the last year or so where lithium-ion batteries, commonly used in power tools, e-bikes, those sorts of things, where they have been determined by the Maryland State Fire Marshal's Office on investigation to be the causative agent in those fires.
But these are fires that you put out?
Yes.
Okay. Okay. Let's talk about the chemistry of these batteries. I presume the battery chemistry is not the standard lithium ion. They're using lithium iron phosphate.
Correct.
But for your purposes, do you make a distinction between these two different types of chemistry?
No, sir. In response to that, again, this technology, and I believe Mr. Latham correctly identified it in his testimony, this industry is evolving even as we sit here.
Mm-hmm.
So what may be current technology today may not be the current technology tomorrow. So, and the fire service, as always, we play catch up, not through any fault of our own. We have to look at available technology, what is coming, what are potential avenues for approach, mitigation, and possible extinguishment.
So you don't take the position, or you don't agree with the argument that says this particular kind of chemistry is inherently safer than lithium ion. You don't take that position.
I don't have enough information or background knowledge on the technology as it stands to give you an informed answer, sir.
Okay, fair enough. So, since you don't have any confidence in being able to put out a substation fire, if the utility wanted to locate another substation in Harford County as fire marshal, what would your position be with respect to that?
Well, first of all, again, those decisions regarding the location of any substation fall under the purview of our planning and zoning department. We would engage, as we have engaged and we continue to engage, with both Delmarva Power, which provides electrical service to a section of our county above Deer Creek, and BGE is the primary utility provider south of Deer Creek. We train with them, we interact with them on a regular basis, and again, our approach to a substation, a transmission line, is first and foremost, is the power off? We will not approach anything until the power is off.
I'm asking that if BG&E said we need to build a substation in a location in the ag reserve.
Okay.
I don't know if you call it an ag reserve.
Ag district. Yeah.
Okay, we call it ag reserve in Montgomery County. Your position would not be automatically to say it can't be built because we don't feel comfortable.
No, sir.
Okay. Because the impression I get is that your position with respect to this battery complex is to say we shouldn't build it because I can't put the fire out.
Our position is, and I'll segregate the positions, if I may. On an electrical substation, there is a process, a finite process, in which the utility provider can render that substation offline.
Okay.
They can do it remotely. They can actually send someone out to the site and shut the power down. And then it's a simple matter of combating the fire based upon whatever's burning. It's quite easy. My understanding and what we know to this point, and we know quite little about any of these lithium iron phosphate, lithium ion, what have you, in these BESS facilities. We know very little as to the technology, as to what are they ever really shut down? Are they still active? Looking at post-mortems of incidents where some of these BES facilities have caught fire in other areas of the country. And in my submitted early testimony, there were some cited examples of those facilities, I believe in California, where despite efforts at extinguishment, thermal runaway continued and may have been exactly exacerbated by the application of some sort of extinguishing agent.
Okay, I have no further questions. Thank you very much for your testimony. And that concludes the segment from Harford County. It is 11:32. Let's take a 10-minute break and come back at 11:45. We'll come back at 11:45, and then we will turn to People's Counsel.
is a quick test. Christine, can you hear me?
I can. Can you hear
Awesome.
me?
Yes, we'll put you on mute until we're ready. Thank you.
Okay, sounds good.
Okay, it is 11:45, so let's get going. OPC.
Thank you, Mr. Chairman. Just a couple matters regarding exhibits before we call OPC's witnesses.
Okay.
On Tuesday of this week, OPC marked 2 exhibits, and I don't recall if we actually formally moved them
do it
into
now.
evidence.
Obviously, I don't either, so.
So we would like, OPC would like to move OPC exhibits 1 and 2 into the record.
So marked and without objection, so admitted.
And then the other matter with regard to exhibits is that OPC emailed several exhibits, exhibits 3 through 6 to the other attorneys in this matter, and to Ms. Schock, who I believe may have circulated them to commissioners yesterday, and we emailed them in anticipation that our witnesses could have possibly appeared virtually yesterday at yesterday's hearing. And so would you prefer that OPC still print copies of those exhibits?
No.
Later?
Electronic is perfectly fine.
Okay, and so just going through those exhibits individually, OPC Exhibit 3 is OPC's response to request for information issued by Power Advisory, and we would like to have that marked as exhibit, as OPC Exhibit 3 and moved into the record.
So marked and without objection, so entered.
Okay, and the next one is a draft RFA issued by Power Advisory that we would like to have marked as OPC Exhibit 4 and moved into the record.
So marked and without objection, so entered.
And the next one is OPC's comments in response to the draft RFA, and that would be marked as OPC Exhibit 5. And we'd like to have that moved into the record.
So marked and without objection, so entered.
And the final one for now is the RFA itself issued by Power Advisory, and we would like to have that.
Oh, I thought you already. Okay, yeah.
Issued, marked as OPC Exhibit 6 and moved into the record.
So marked and without objection, so entered.
Okay. And with that, we would like to go ahead and move to our first witness.
Sure.
Which is
Call up your first witness.
So we'll call our first witness, Michael Freeman.
Okay.
Please raise your right hand. Do you solemnly swear to the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell it, tell us what your title and place of employment and address is.
Michael, M-I-C-H-A-E-L, Freeman, F-R-E-E-M-A-N. I'm self-employed Emerald Energy Consulting, LLC, and I'm located at 822 Montgomery Avenue, Suite 303, Narberth, Pennsylvania.
Thank you.
And may I approach the witness?
You may.
So do you have in front of you a set of pre-filed written testimony dated July 15th, 2026,
Yes, I do.
And consisting of both public and confidential versions of your testimony?
Yes.
Consisting of 32 pages of testimony and 2 exhibits in the public version and 3 in the confidential version?
Yes.
Is your testimony true and correct to the best of your knowledge, information, and belief?
Yes.
If I asked you the same questions today, would your answers be the same?
Yes.
Do you adopt that pre-filed testimony and the accompanying exhibits as your testimony in this proceeding?
Yes.
Mr. Chairman, OPC requests that the pre-filed testimony of Michael Freeman, together with the accompanying exhibits, be admitted into the record as OPC Exhibit 7 and 7C for the confidential version.
So marked and without objection, so admitted.
Mr. Freeman is available for cross-examination.
Okay, let's begin with RWE Supply.
Thank you, Your Honor. RWE has no questions for this witness.
Cardinal Energy.
Thank you, Mr. Chairman. Good morning, Mr. Freeman. Morning. I'm Carville Collins. I represent Cardinal Energy Storage. I understand your testimony to contain a number of recommendations, one of which is to narrow the field of applicants down to 1, correct?
The current field, you mean?
The current field.
Yes, that's correct.
And in connection with the one bidder that you recommend for selection, you believe that Power Advisory's evaluation of capacity, price, impact, and ELCCs are overestimated, correct?
Possibly overestimated, yes.
After adjusting for these overestimates, you find that this one applicant should have a benefit cost ratio of 1.09, just above the 1.0, is that correct?
That's correct.
And you recommend that the 1.0 threshold for the benefit cost ratio serve as a cutoff, correct? In other words, those above versus those below, and that the 1.0 threshold would be a cutoff, is that correct?
From a quantitative perspective, yes.
And in addition, you are also recommending in your testimony a number of measures for subsequent energy storage procurements, reducing risk to ratepayers but allocating that risk, including new liquidated damages and collateral requirements for developers. Is that correct?
That's correct.
Do you make in your testimony any reference to the state's energy storage goals?
I believe I do. I mentioned the NGEA.
You mentioned the NGEA. How will the state achieve those goals based on the testimony that you've presented?
Well, I think the goal is 1,600 megawatts by 2031. Subject to check, I believe that's correct. My issue is balancing risk. Ultimately, I don't know how to answer your question, except to say I think that the state should move forward with these procurements in an attempt to reach the goal, but in a framework that better balances risks between ratepayers and generators.
You mentioned that you do reference the goals because you referenced the NGEA in your testimony, correct?
Yes.
But the goals were enacted not as part of the NGEA. Isn't that correct? That was 2 years earlier, wasn't it?
You know, I'm not really sure.
Do you know what those goals are?
I know the numerical, the 1,600.
1,600, and what, by what date was that?
I believe it was 2031.
Okay. Are there any other goals or milestones that were in that statutory goal construct?
I'm not sure.
No further questions. Thank you.
Okay. Renewables.
No questions for this witness, Your Honor.
Chalk Point.
Good morning, Mr. Freeman. My name is Maggie Witherup. I'm an attorney for Chalk Point Reliability Storage LLC.
Good morning.
I have just a few questions for you. In your adjusted methodology, you recommend reducing the battery ELCC by 10% across the board, correct?
Correct.
And that's because you believe that Power Advisory and CES overestimated ELCC.
I do. Based on the supply stack that CES forecast as it compares to the supply stack that PJM forecast.
Would you agree that ELCC is a measure of multiple factors?
Yes.
And that lowering of ELCC was not communicated to anybody who participated in the first round of the RFA in this case?
I do understand that, yes.
Would you agree that the Commission has discretion to determine that qualitative factors or non-quantifiable benefits could warrant consideration of a project that has a benefit-cost ratio of less than 1?
I do, yes.
And that's regardless of the methodology that's used, correct?
I believe so.
Would you agree that the modeling approach used by Power Advisory and Customized Energy Solutions was a reasonable approach?
Well, there were modeling decisions made where I would have made different decisions. Overall, I think it was reasonable.
Thank you. No further questions.
Okay. Harford County.
I have a few questions. Thank you for being here, sir. It's still technically morning. Grant Giel on behalf of Harford County. I understood previously you stated the 1.0 threshold should serve as a cutoff.
Yes, quantitatively.
Quantitatively, do you believe that the oyster catcher facility is currently underneath this threshold?
Yes, that's my understanding, yes.
And you just testified that the Commission has discretion to determine that non-quantifiable benefits may allow the approval of projects that have a score of under 1.
Yes.
Do you believe that it should exercise that discretion in this particular case with regards to the oyster catcher facility?
I'm sorry, restate the
Do you
beginning.
believe that the Commission should exercise its discretion and approve the oyster catcher facility?
I don't know if I can judge that. Certainly, the statute says that the Commission can consider benefits that may not be quantifiable or qualitative benefits. In this case, I can't judge whether they should or shouldn't.
If you were a decision maker, would you approve the project?
Based on qualitative factors?
Yes.
Well, I would take into consideration some of the testimony I've heard today and yesterday. Mr. Latham yesterday and the planner, I didn't catch his name.
Mr. Leitner.
And the fire chief. They raised significant issues, and I think they have to be dealt with before this project can even be considered.
Thank you. No further questions.
Okay. MEA is not here. Sierra Club.
Thank you. I have a few questions. Good morning, Mr. Freeman. I'm sorry, Amiel on behalf of Sierra Club. So you did get some questions about the statutes in Maryland, but I'm going to try to ask a few more to maybe clarify which statutes. So are you aware that the Next Generation Energy Act anticipates a procurement of up to 800 megawatts of storage, correct?
I think that was, yes, but I think it was actually raised by an amendment.
Yes, that was my next question. So I assume that you're aware the Utility Relief Act specifically removes the 800 megawatt limit for this procurement, right?
Yes.
But you recommend approval of only one of the proposed projects, as you testified, correct?
Yes.
And just to confirm, do you recommend approval only if certain additional conditions are met related to the benefit cost ratio and the ELCC projection?
Yes, I would prefer to see projects judged with a different ELCC forecast and a different capacity price impact methodology.
Okay, so if those two conditions are not met, would you no longer recommend approval of the fourth quarter BEST project?
No, I would still recommend it, because when you amend the modeling approach for those two factors, it still is above one.
Okay, so you're not fully wedded to those conditions. You would still recommend the one out of the four projects.
Well, it's my preference that those conditions be imposed on the modeling, but I understand the issue of particularly the ELCC not being in the original RFA.
Okay, thank you. And so this, I believe, Council had asked about this previously, but are you familiar with the Energy Storage Act's requirements that Maryland obtain 750 megawatts of energy storage capacity by delivery year 2027?
I have read it, and I didn't recall that earlier deadline, but yes.
Okay, thanks. This is the 2023 legislation that you answered questions about previously. And are you familiar with the Act's requirements to obtain its 1.5 gigawatts of cumulative energy storage by delivery year 2030?
Yes, I was saying 2031. It's delivery year 2030-31. Yes.
Yeah, that's right. Okay, and are you familiar with the Act's requirement to obtain 3 gigawatts of cumulative energy storage by delivery year 2033?
Yes, I am.
Would you say Maryland's currently on track to meet those storage deployment goals?
Well, no, I would not say that. It's very difficult to meet those goals, in my opinion.
Okay, thanks. And despite recommending disapproval of 3 out of 4 of the projects proposed in this RFP, have you proposed any other policy mechanism that can ensure Maryland meets these statutory storage adoption goals?
Policy, no. I made recommendations as to the standardized agreement that would govern these transactions. But from a policy viewpoint, I had no opinion.
Okay. Like, for example, do you think it would be better for utilities to build their own transmission-connected storage projects rather than having an RFP procuring storage from third-party developers?
I don't.
Okay, looking at page 7 of your testimony, do you have your testimony in front of you?
I do, yes.
So on page 7, I'll wait for you to get there. I have a quote from it. On lines 6 through 8, you mentioned that 2 benefits of the fourth quarter BEST project are the price suppression impact of additional capacity on wholesale energy and capacity costs, as well as avoided transmission system costs. Does that sound right?
Yes.
This price suppression benefit was considered in Power Advisory's benefit cost analysis, right?
Correct.
And can you please explain why adding more storage to the grid is expected to drive down wholesale energy and capacity costs?
Well, they're two separate markets, two separate questions.
That's true.
In terms of capacity, the theory is that the addition of unforced capacity associated with this reference resource that was used in the modeling would be added to the supply curve in PJM and would have the impact of lowering the clearing price in capacity auctions because of the addition of it to the supply curve. In the case of the energy market, the theory is that the introduction of 800 megawatts of energy into the energy supply curve would cause redispatch of fossil units and lead to lower prices.
Okay.
Lower marginal prices.
Okay, thanks. That's helpful. And those are benefits that any proposed transmission-connected storage project would be expected to bring about in some measure, right?
The capacity price impact one is, to me, highly questionable. I don't think, and I describe this in my testimony, I think a more conservative approach really makes a lot more sense than what has been done here. For one thing, there's no, let me back up. The preface to all this is that you're telling the ratepayers, no matter what happens in terms of the deemed capacity revenue, if it's higher or lower than expected, there will be an offset benefit from the capacity price impact, in that capacity prices will be lower, and you'll benefit from that. And it makes up a large proportion of the benefits in the analysis, the capacity price impact. And I don't think it's good to make a decision on a project based on the proportion that has been modeled in this analysis.
Okay.
It's anything but a sure thing.
Okay, if I can take a step back, because I think my question was a bit more general. Would you agree that there's currently a capacity shortage in the PJM system?
There's an anticipated shortage of about 6,000 megawatts by delivery year 2930, I believe.
Okay. And this is contributing to rising electricity prices for Marylanders?
Well, it's contributing to the capacity market clearing at the now state-imposed cap.
Okay. So, in other words, bringing online more storage can mitigate some of that capacity shortage and high prices. Would you agree?
It's possible.
Okay. And then turning back to that same statement, you also cited avoided transmission system costs as another benefit of the fourth quarter BEST project, right?
Yes.
Are you familiar with the statement in Power Advisory's report that there's nothing that distinguishes the fourth quarter project from other applications with respect to avoiding or deferring transmission investments?
I have seen that, yes.
So theoretically, any of the other three storage projects could also result in avoided transmission system costs, right?
Theoretically, yes.
And this could also put downward pressure on electricity prices, right?
Yeah, but the impact of that is over a longer period of time, I would say.
Okay. Okay, I'm almost finished. Power Advisory created 2 opportunities to comment on the criteria they would use to select projects, right?
I'm sorry, repeat.
Power Advisory created 2 opportunities already to comment on which criteria they would use to select projects, right?
I'm not sure.
So and I'm referring to the RFI stage and the RFA stage of the projects.
I see. Okay. Yes.
So did OPC provide comments at the RFI stage?
I don't know. I wasn't working for OPC at the time.
Okay, and do you know if OPC commented at the RFA stage?
I believe they did.
Okay. Are you familiar with witness Dalton's rebuttal testimony that stating that OPC did respond to both the RFI and the RFA already?
I wasn't aware of that, no.
Okay. Thank you. Those are all my questions.
Okay, thank you very much. Staff.
Just a couple quick questions. Mr. Chairman, thank you. Good morning. Good afternoon, Mr. Freeman.
Good afternoon.
Just to be clear on your testimony, OPC is recommending just one project be accepted by the commission, is that correct?
That's correct.
And by accepting only one project, wouldn't that put the commission well below its 800 megawatt target?
It would, yes.
And how do you propose the commission make up that shortfall?
Well, there are several different options. One is to accept just the one, 300 megawatts, and be short, and then for the second procurement, raise the goal over the. I guess another relief amendment would have to be, or act would have to be approved. That's option one. That's the second option would be to throw out all the results and start all over again. I don't recommend that. And the third option would be to accept more of the projects. For example, Chalk Point was fairly near the benefit cost threshold of 1.0, but impose some ratepayer protections in the contract, which to me would be my preferred option. And again, knowing that none of this was described in the RFA, and the offers that were given were based on a belief that ELCC risk, for example, was all on the ratepayers. I don't think that's fair. I don't think that's right. And I think that if there was an opportunity to create a standardized agreement with more ratepayer protection against the risk allocations that currently exist, then I could see accepting more projects in this round. That would be my recommendation.
Thank you. Staff has no further questions.
Okay, redirect?
Yes, Mr. Freeman, hi. I do have a couple questions. There is a question on cross as to whether the 1.0 should be a threshold or cutoff, the 1.0 quantitative evaluation. And are you aware that there's also qualitative benefits as well that aren't included in the quantified analysis?
Yes.
Would you agree that if a facility had slightly below 1.0 in its quantified analysis, say 0.99, that an aspect or aspects of the qualified analysis could still result in the commission potentially accepting that application?
Yes.
But you would agree that the quantified portion is the primary, is at least the primary determinant between the quantified and the qualified?
I know CES tried different proportions to go to that question directly. They tried 60% quantitative weight and 40% qualitative weight. Then they tried 70-30, same order. And the results came to be pretty much the same. I don't think weighting really gets you to the answer to your question, which is if something is at or near 1.0 quantitatively, but qualitative benefits were such that, and when I say qualitative benefits, it's the range of things from how ready are they to commercial operation? Have they gone through all the interconnection steps of PJM? Is there community opposition or not? Is the site, does the site need a whole lot of civil engineering, and so forth and so on? If the scores are high there, then the commission has the discretion, and I think it's proper to say, okay, they may not have hit 1.0, but we're okay with projects from a net present value basis being 10%, for example. I'll just throw a number out there, 10% below NPV 0, like total indifference, where we can actually consider qualitative benefits even though the quantitative score isn't what we'd like to see, what we'd prefer. And then a project could be potentially approved.
Okay. And do you remember being asked on cross-examination as to whether there were 2 rounds of comments with regard to Power Advisory's procurement process? Do you remember that
Yes.
line of questioning? Do you remember one question being as to whether there was a comment regarding the Power Advisory's request for information?
I don't know.
Okay. Would it surprise you if Power Advisory issued a request for information and the comments in response weren't submitted before the commission in any docket?
Power Advisory submitting a question?
Power Advisory issuing a request for information and the resulting comments from OPC and other parties were never submitted before the commission.
That would surprise me.
In a docket.
Yes.
And do you remember the line of questioning regarding another round of comments regarding a draft RFA issued by Power Advisory?
No. I don't recall.
Okay. Well, would it surprise you if Power Advisory issued a draft RFA and a comment period, and parties such as OPC and others filing comments, and they were not posted anywhere in a docket or anywhere else?
That would surprise me, yes.
And do you know whether the commission had any input on any decisions with regard to any of those comments that were submitted, either in response to the RFI or the draft RFA?
I don't.
And would it surprise you if the commission made no decisions and there was no there was no expression of whether Power Advisory made any decisions with respect to those comments?
Yes, that would surprise me.
No further questions.
Okay, we'll proceed to the bench. We'll start with Commissioner Suchman.
Good afternoon, Mr. Freeman.
Good afternoon.
So I actually would like to explore a little bit the risks that ratepayers are going to assume in this program. Now the load serving entities are required to purchase storage capacity credits based on the price schedule that was offered by the companies, correct? So we know, I mean, assuming we accept these projects. So we'll know whether we accept 1, 2, 3, or all 4, what the ratepayers are going to be on the hook for. We don't necessarily know. So those are the known costs. In terms of the benefits, those are not known. We can speculate about what we're going to see in terms of benefits, but we don't necessarily know how the markets are going to behave. And there's been all kinds of testimony about adding more storage will actually serve to depress the value of the project. But we do know that there's going to be this chunk of money that ratepayers are going to be on the hook for, regardless of how the projects perform in the markets. I'm struggling to figure, and all my questions are going to be non-confidential, because I don't even know how we do it if I'm asking questions about all the projects. So I'm gonna attempt to do this without having any confidentiality sort of presented. But is there a way that we can quantify how much the ratepayers would be on the hook for without looking at the actual price schedules being offered by the developers? Is there any way? Do we have a general sense of what each of the projects would represent in terms of ratepayer risk?
You're talking about net, on a net basis, cost minus benefit?
I'm trying to. No, not net.
Oh, okay.
Because the problem is that the benefits are speculative, and speculative. Not that they're not going to happen, but they're speculative in the sense that I can't know what we're going to get in terms of benefits.
Could you restate your question, because I've gotten kind of lost here?
Well, I think the witness. So I'm just looking for costs. I'm looking for the known. What are the load serving entities going to be paying 1, 2, 3, or 4? Do we know those numbers?
We do.
We do. Okay, but those numbers are confidential.
Yes.
Okay. So that's but they are large numbers. I mean, the problem is, like, for example, Empower. which ratepayers are on the hook for. That I know is about $500 million a year. We know what those numbers are. Ratepayers don't. I guess they won't know until we accept a project, and then that price schedule will be known at that point.
I assume so, yes.
Okay. So you couldn't today share, based on each project, what the ratepayers are going to be facing in terms of risk.
No, I couldn't share that, but you could do a reasonable estimate from public domain information.
Oh, well then share, please.
One of the authoritative studies on storage cost is Lazard. Lazard does a levelized cost of storage study every year since, it's probably at least 10 years now. They're in their at least 10th year of analyzing. And I just looked at it today. The current, their current low-end estimate of 4-hour is for 100 megawatts. So lower than the scale we're talking about here. But 100 megawatts, 4-hour duration is about $210 a megawatt hour for CapEx.
Okay.
CapEx is about 60% of the total cost of a project on an ongoing basis. So there's fixed O&M, there's
Okay,
small-
so if you have just a sample 400 megawatt project, just ballpark, what would the ratepayer be on the hook for on an annual basis for that project?
400 megawatts, 4 hours, 1,600 megawatt hours times 210 a megawatt hour. That's just CapEx. That's not inclusive of the federal income tax credit.
Right. No, I appreciate that. And so that's, do you have a calculator?
I do.
Okay.
Oh, here's one.
Okay. We had no idea.
All right, 210 times 1,600 is not right. Sorry. It's levelized cost. That's why. It's levelized. It's not initial. It's, I'm sorry.
It's life cycle, isn't it?
Yeah, so let's do 210 times 1,600.
And the reason I'm asking is because, ratepayers are paying attention to this proceeding, and oftentimes the numbers are nonsensical to them. They don't understand the BCA analysis, and so if we can at least offer ratepayers a sense of what this means in terms of dollars. So what did you come up with?
Well, that for 400 megawatts, it's going to be in the neighborhood of this is just CapEx, not subsidized. It's going to be $200 million or
Okay.
something like that.
Okay, so that's just for one project.
Yeah.
Okay, so that's the known costs, and then we have to hope that the markets behave, because the ratepayers are taking on the risk, the developers not, and so we're sort of putting ratepayer money at risk. We want to make sure that we're doing it right.
If I could just make one
please.
clarifying comment, the developers, the project company that represents these projects, they are taking price risk in the energy market. They're basically merchant plants. They're depending on spot market energy value, both charging and discharging, to make the rest of their return on equity.
Okay. No, I appreciate that,
Okay.
and that was unfair of me. Okay, so that I am going to actually ask you questions about what I know is non-confidential. So, and in looking at your testimony on page 11, and we don't have to go through the specifics of it, but you did suggest that there's that the evaluation likely overestimated benefits. But if we accept the calculation as correct, and if we look at the power advisory, do you have that report?
Yes.
Okay. If you look on page 3.
Oh, I don't have it with me. I'm sorry.
Okay. Counsel, do you have a copy of the report? I mean,
I could bring it up on my computer.
Okay, well, I actually have the confidential version of it, which I'd be
If you'd
happy
like-
to,
if
so
you'd
I'd be
like
happy
to,
to, okay.
approach the witness,
Thank you,
yeah.
that would be great.
Oh, I don't know if that's the well, that's.
I don't need I don't want the confidential version. I
okay.
just have it, so, and my questions are gonna be related to the non-controversial, okay. But that's the
That's the public
That's
version.
the public version. Okay,
Page 3?
right, page 3. And if you look at the table ES-5, and you look at the second column, levelized net credit per residential customer. So this is both quantifying, doing the BCA. So you've done the benefit and the cost. You've assumed greater benefits in this than you had calculated. But assuming that that's correct, if we've got this sort of list of cost, I mean, what it's showing for me is that other than the fourth quarter BSS, everything else is underwater. But that the oyster catcher is substantially underwater. So is that what you're seeing?
Yes.
And is this cost per year, per month? Do you know?
It's unclear. Looking at it now, I realize I don't understand the units.
Okay, because I didn't understand the units either. That's why I was asking you. Whatever they are, the units are showing that of all of the projects, the oyster catcher doesn't even come close. And the others come closer, much closer. If we were to rely on your analysis, these numbers would go in. The negative numbers would go more in the negative direction. Is that your sense?
Yes,
Okay.
correct.
And how would the fourth quarter BSS do, the A project?
It would still be positive, but I don't know. Without knowing the units, it's hard to tell.
Okay.
And for the divisor, I guess they used number of residential customers, which I also don't know. But
Okay, that's all I have. Thank you.
Commissioner Hoover.
So I want to go back to your discussion with staff counsel. Is it your position that if we adopt the ratepayer protection provisions that you've suggested, that you could see us approving more of the projects that have been proposed? Now, does that get to the 3 that Power Advisory mentioned, or is that more?
well, one of the 3 dropped out.
Okay.
So it would be Chalk Point, I guess option C, plus fourth quarter best option A, I believe. Just looking at the BCAs right now, the benefit cost ratings. But it really comes down to a decision about not only the contract and the risk allocations being balanced more than they are. It's also the commission's consideration of things like, are we going to hit the goal or not? If we don't hit the goal this time, what are the implications for the next RFA? Will the market get skittish about offering into Maryland's process? Those are things that need to be considered. I have opinions about each one of those, and I don't think there's a. I think if we went back and said, okay, we will institute these amendments to the contract, well, the contract's in draft form, but if we adopted something like the ELCC measure that I recommended, then the commission could have more confidence, I think, in the benefit side of these calculations than than the level of confidence I have in them right now.
Okay. All right. Thanks.
Commissioner McLean.
No questions, sir. Thank you.
Linton.
No questions.
Okay, I have a couple of questions. Let me just say at the outset, the legislature didn't give us I don't believe they gave us the ability to say, the legislature wants batteries and they want them utility scale, And the reason they want them is because they want to encourage renewable energy, which is an intermittent source of power, and really it's just not practical to create a big chunk of our grid as renewable unless we have battery storage. Do you fundamentally agree with that?
I do. But it's more than renewable energy. It's the system will need fast dispatchability
Right.
and flexibility, whether it comes from batteries or combined cycle.
Right, but at least with respect to the NGEA, that was their intention. Okay. Okay, glad we're agreeing to that. Second, you don't like the idea of the ESCC price schedule being fixed for a period of time, I take it.
No, that isn't my objection. It's
that's not.
It's that the standardized agreement in draft form right now doesn't. It accepts that the payment is fixed over 15 years.
Okay.
But it doesn't have provisions that would draw down on that payment in the event of performance that was below what is expected.
Okay, so basically you don't, well, let me restate what I think your position is. You believe that the ESCC schedule should be flexible according to where the market moves. Is that basically?
No, I'm saying, I'll give you an example.
Yeah.
I've suggested in the standardized agreement that if a project doesn't clear its entire accredited capacity in a capacity auction, that the difference between what it would earn for ratepayers through the RPM revenue and what it is earning by clearing an amount lower than its accredited capacity should be deducted from the ESCC payment during that delivery year.
Okay. I realize that there aren't a lot of, maybe we're the first state doing this. I can't remember exactly, but are there any other states that have addressed this issue in this manner?
Yes, New Jersey.
Okay, and how have they done it?
It's the same idea. There's a gap analysis performed, much like what CES did. The gap being the gap between cost and revenue. With storage is, we would say, out of the money. It's not economic. It needs subsidies to survive. And that may be true for the foreseeable future. So the way New Jersey did it was they asked developers to tell them how much missing money, as it's called, what is the missing money, how much missing money they would need to build their project. And that money came in either a lump sum at commercial operation or amortized over 10 years. The developer could choose. And then the developer was merchant in all wholesale markets, energy, capacity, ancillary services. Then the customers at that point had no commercial relationship with the projects. So that's different from what we have here. And I also want to say, because there were some questions about it in rebuttal, that the New Jersey process and this process are not analogous because of that capacity market interaction. In New Jersey, the developers are in the capacity market. They don't turn over any RPM revenues to the ratepayers, as we're doing here. But it seemed to me that the offers that were given in the Maryland process contained a value for foregone capacity revenue. In other words, the developers, knowing that they have to transfer all RPM revenues to the ratepayers, and they won't see a penny of it, incorporated in their offers, not all the offers, but some of them. They were too high to be credible without this element. So when I say I think the two processes are analogous, that's why I say it. But in the case of New Jersey, all wholesale markets go to the developer.
Okay. All right, let's talk a little bit about ELCC ratings. These calculations, as they're done by PJM and by others, they're not an exact science. Can we agree on that?
I would agree.
Okay. So here's here's a concern I have about this analysis. We are, and I think what People's Council is attempting to make us do is to really sharpen our pencils to carefully calibrate a policy. But the problem in my mind is the variables are constantly moving. They're constantly changing.
Right.
And it causes me to wonder whether that degree of precise calibration is even possible.
It's not. I'm not trying to say it is.
Okay.
All I'm saying is none of us knows what's going to happen in the future in the markets
Right.
in particular. And the best we can do is risk manage the risk in the contract. Like if we want to say, okay, the ELCC is going to be 25% in 2041-42, and we're basing what we think are ratepayer benefits on that assumption, just that one assumption alone. There are many others, but the only way to gain some confidence about that estimate, that forecast, is to contain the risk in the contract. It's the only thing anyone can do. You can have flexing based on the market, which is something that Illinois is doing with storage. They have a contract for differences set up. And I believe New York is doing the same thing. So there is some flexing of variables as the contract goes on, which is not a bad idea. But in this case, since we have fixed capacity payments that are based on installed capacity and unknown capacity revenue that's based on unforced capacity, which is way lower, then the only way to cope with that from a ratepayer perspective, to me, is to contain it with risk management.
Okay, I can imagine, I shouldn't put words in the mouth of the developers, but I can imagine where a developer would take the posture of saying, you know, I like having this fixed price schedule. This gives me contract certainty. This allows me to take a risk and invest my money, whereas your proposal would have substantially less certainty, wouldn't it? I wonder if a business owner, if a developer would participate if we adopted the recommendations you're proposing. That's what I'm asking.
With respect to the ELCC? Well, they'd have to run the numbers, and I think when they do that, they'll find that the impacts are not as bad as they would seem upon first glance. I mean, this all ought to be modeled, which I've done, and assuming my recommendation, which I think is confidential, but I had a recommendation to deal with the ELCC. I modeled the impact of it, and I don't think it would cause a project to be unfinanceable.
Okay. Thank you very much.
Just one follow-up.
Okay, a quick one.
I just wanted, if we go back to New Jersey, I just wanted to get a sense from you of where that money was coming from. Is that a ratepayer money or is that state money?
It's ratepayer money ultimately.
Okay, and how, so who made the determination about how much each project would need?
Well, to be honest, we did. I worked with IEC and another company, TRC. We built a dispatch model, a battery dispatch model, to try to assess where the offer should be at based on common assumptions about cost and forecasted assumptions about revenue. So the commission in New Jersey could be educated about, okay, if you see an offer that's 10% higher than this, that's cause for you to push back, possibly. If you see something lower, that gives you, this benchmark gives you a little more confidence that the offer is economic.
Okay, and then how was the, and so what is it, how is it recovered from ratepayers? Was it sort of a line item?
I believe it's a surcharge.
Okay. All right,
on
thank
the
you.
bills.
Okay, that was useful, but I again want to emphasize that the legislature isn't asking us, they're telling us. Okay, thank you very much for your testimony.
Sure.
It is, You know, we'll take your last witness, and then we'll do lunch. Hmm? Oh, that's true. yeah.
Good afternoon, Ms. Lee. Do you have in front of you a set of, or sorry, yeah.
I think she needs to be sworn in first.
You got it. Ms. Lee, can you hear us, by the way? Okay.
Yeah, yeah. Can you hear me?
Yes.
Ms. Lee, did you raise your right hand, please? Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
And if you could just state and spell your name, tell us what company you work for, and what your address is.
Yes. Christine Lee. CHRISTINELEE. I work for Industrial Economics Incorporated. We are located in Massachusetts, 267 Massachusetts Ave, 4th floor, Cambridge, Massachusetts, 02140.
And also, can you assure us that you are testifying by yourself and you have no aid to anybody who's off camera?
Correct.
Okay, thank you.
Good afternoon, Ms. Lee. Do you have in front of you a set of pre-filed testimony dated July 15th, 2026, consisting of 20 pages of testimony and one exhibit?
Yes.
And was that testimony prepared by you or under your direction?
Yes.
Do you have any corrections or changes to make to your testimony or exhibits?
No.
Is your testimony true and correct to the best of your knowledge, information, and belief?
Yes.
If I asked you the same questions today, would your answers be the same?
Yes.
Do you adopt that pre-filed testimony and the accompanying exhibits as your testimony in this proceeding?
Yes.
Mr. Chairman, I would OPC request that the pre-filed testimony of Christine Lee, together with the accompanying exhibit, be admitted into the record as OPC Exhibit 8.
So marked and without objection, so admitted.
And Ms. Lee is available for cross-examination.
All right, thank you. Okay, RWE Supply.
No questions for this witness, Your Honor.
Cardinal Energy.
No questions.
Rev Renewables.
No questions, Your Honor.
Chalk Point.
No questions, Your Honor.
Harford County.
Contrary to my email yesterday, I do have a few quick questions.
Go for it.
You identified on page, I think it was 9. Give me a moment to double check. Sorry, 15. On page 15 of your testimony, lines 11 through 20, you talk about the difference in qualitative evaluation of economic benefits. And you identify and state that I'm going to actually summarize it slightly. 4 of the projects, the difference between them indicates that the difference in scores reflects primarily differences in the level of detail of each applicant's plan. And you state parenthetically that you leave aside the lowest scoring oyster catcher. Why do you leave aside the lowest scoring oyster catcher in this testimony?
Objection, Mr. Chairman. At the outset, you announced a rule about friendly cross, and this appears to be taking us down that road. So on that grounds, we would object to the question.
Objection sustained.
I assume that the objection is going to be sustained for the other question then, so I will have no further cross-examination questions.
Very well. MEA is still not here. Sierra Club.
Yes, I do have a few questions. Okay. Good afternoon, Miss Lee. Can you hear me? Okay. Great.
Yes, I can.
Thanks. So it's your position that the qualitative evaluation of storage projects should only be applied to projects with a benefit cost ratio at or close to 1 or greater. Is that right?
That's correct.
In your testimony, did you evaluate each of the projects on a qualitative basis, or did you adhere to your recommendation that the qualitative evaluation only be done for projects with a high benefit cost analysis?
Well, I did review the entire qualitative evaluation that was presented in the Power Advisory report.
Okay, so you evaluated each of the projects, even ones that had a lower BCA?
Yes, in part because I was evaluating the entire report to provide comment and recommendations.
Okay, thanks. Do you have your direct testimony available?
Yeah, yes, I do.
Okay, thanks. Can you please turn to page 8 and read the sentence from lines 10 to 13? I can say the lines again if you... I'll give you a minute.
Yeah. I'm sorry, page 8 you said? Is that right?
Yeah. And so there's a sentence from lines 10 to 13. It begins with conversely.
Conversely?
Yes, thank you.
Yes.
And yeah.
Yep. Conversely, a project could show a benefit cost ratio of less than 1, but have other benefits not considered in the quantitative evaluation that merit active consideration for approval. Therefore, considering these qualitative factors is important.
Thanks. So how would you reconcile this statement with your opinion that a qualitative evaluation of storage projects should only be done for projects with a BCA around 1 or higher?
Yeah. What I would say is just that what I'm trying to make the point of, I guess, is that we, as I mentioned later in my testimony, that you wouldn't want to necessarily approve a project that has significantly higher costs than benefits based solely on qualitative criteria.
Okay. I think that makes sense. I just wanted to confirm. Okay.
Yes, and I agree qualitative factors are important, as I said in my testimony.
Okay, so it's not your opinion that only a project with a benefit cost analysis above 1 should be considered?
No, and yes, that is not what I said in my testimony, and I would agree that qualitative factors can be important or even more important when it comes to projects that may have a benefit cost ratio of less than 1.
Okay, thanks. So you're also recommending that Power Advisory's qualitative evaluation include fewer variables, right?
Yes.
Okay, and to confirm, are you recommending that Power Advisory essentially go back to square one and redo its qualitative analysis, or are you providing recommendations for future RFPs such as the 2027 RFP?
I am recommending mostly to consider lessons learned or recommendations for the next round, and also trying to provide some insight into the value of this qualitative evaluation to the commission as part of RFA 1.
Okay. And your testimony has a table listing the qualitative factors that Power Advisory considered on page 6, right?
Correct.
Okay, and just looking at that table, do you agree with the importance of considering each project's viability?
Yes.
Okay, are you recommending Power Advisory not consider applicants' experience?
No. Okay,
so you would agree with that being a qualitative factor?
Yes.
Okay, thanks. Sorry, it's a double negative question. What about the safety plan of a project?
I agree it's an important factor.
Okay, and are you recommending that stakeholder engagement no longer be considered in project selection?
Nope, I am not suggesting that.
Okay, and what about the local and statewide economic benefits?
No.
So which of the qualitative criteria are you recommending be removed?
It's not that I'm recommending removing it, but revising the scoring, like the approach and the scoring approach, so that way there's not so many variables that, at least with this current 30-60 or 30-70, 60-40, it just makes each of these different criteria have a very small value, so it doesn't contribute a lot to the score or change or provide a lot of room for a differentiation between projects. And so, for example, project viability, it includes, a number of different characteristics, and while you can still consider those characteristics, a different scoring structure might be more effective in providing better information to the commission in terms of, again, project viability and non-quantified benefits.
Okay, but you don't object to the inclusion of most of the qualitative variables that Power Advisory did consider, right?
Yes.
Okay. And overall, is it your position that the criteria that Power Advisory used to evaluate the projects do not comply with statutory or commission directives?
I'm sorry, can you repeat that again?
Yeah, of course. So is it your position that these qualitative criteria do not comply with any statutory or commission directives?
No, I said in my testimony that I think they are aligned with the requirements or objectives that were set out through the NGEA.
Okay, thank you. Okay, those are all my questions. Thanks.
Okay, staff.
No questions.
Alrighty, redirect?
I have nothing on redirect. Thank you.
Okay, we'll go to the bench. We'll start with Commissioner Hoover.
Actually, no questions.
Okay, McLean.
No questions, sir.
Linton.
No questions.
Suchman.
No questions.
I have a question. Here's this as a thought. One of the projects, the one that has the lowest BCA, is a 6-hour battery versus a 4-hour battery. Should that be considered as a factor? And if so, a major factor, a minor factor? What do you think?
It should be considered as a factor, and it could be considered as a factor in the quantitative modeling section as well if it was adjusted appropriately. But yes, it should be considered a factor.
Do you think it's a major thing or a minor thing?
That's not something I considered. I'd have to think about that.
Okay.
It would be one of, there's many factors here to consider, and I think major or minor is somewhat subjective.
Yep, it is. Forgive me. Okay, thank you very much. I have no further questions, and thank you for your testimony. That concludes People's Council's witnesses. It is now 12:50, so why don't we come back at 1:30 for a lunch. All right, it's 1:30. Let's get going, and we are turning to staff.
Staff would like to call DeAndre Wilson.
Okay.
Ms. Wilson, please raise your right hand for me, please. Thank you. Do you solemnly swear to tell the whole truth in your testimony, so help you God? Yes. Thank you.
We know you, but for the record, give us your name and who you work for.
Yes. Good morning. My name is DeAndre T. Wilson, and I am the Assistant Chief Engineer for the Maryland Public Service Commission.
Good afternoon, Mr. Wilson.
Good afternoon.
Now, in front of you in that binder, do you have a document that is dated July 15th, 2026, titled Direct Testimony of DeAndre T. Wilson on behalf of the staff of the Public Service Commission of Maryland?
Yes.
Was this document prepared by you or under your supervision?
Yes.
Is that testimony contained therein true and accurate to the best of your belief?
Yes.
Are there any changes that you would like to make to that document?
No.
So if I ask you the same questions today, would the answers remain the same?
Yes.
Would you like to adopt that testimony found within that document as your direct testimony in the proceeding today?
Yes.
Okay. So, Mr. Chairman, I would like to mark Mr. Wilson's direct testimony as Staff Exhibit 6. There's a confidential version that I would like to mark as Staff Exhibit 6C as well.
So marked and without objection, so entered.
Thank you. All right, moving on. Do you have another document in front of you that is dated July 30th, 2026, entitled Rebuttal Testimony of DeAndre T. Wilson on behalf of the staff of the Public Service Commission of Maryland?
Yes.
Was this document prepared by you or under your supervision?
Yes.
And is the testimony found therein true and accurate to the best of your belief?
Yes.
Are there any changes that you would like to make to the rebuttal testimony?
No.
So if I asked you the same questions today, your answers would remain the same?
Yes.
And would you like to adopt that testimony found in that document as your rebuttal testimony in the proceedings today?
Yes.
All right. Mr. Chairman, I would like to mark Mr. Wilson's rebuttal testimony as Staff Exhibit 7 and enter it in.
So marked and without objection, so entered.
Thank you. Mr. Wilson is now available for cross.
All right. RWE Supply.
No questions, Your Honor.
Cardinal Energy.
No questions, Mr. Chair.
Rev Renewables.
Yes, very briefly, and if you don't mind, I'll just do it from the podium here.
Sure.
Good afternoon, Mr. Wilson.
Good afternoon.
I just wanted to clarify for the record, the analysis that you've done in your testimony versus the qualitative analysis done by Power Advisory in their report, and to make sure that I'm clear, in your testimony, you are providing an engineering analysis that's independent of Power Advisory's qualitative analysis. Is that correct?
Yes, it's a complementary analysis.
Okay. And in Table 1 of your direct testimony on pages 80, 81, and 82, you provide a comparative engineering readiness assessment.
Yes.
Correct. But you didn't do a scoring or ranking of the projects relative to each other, did you?
No.
Okay. Thank you. No further questions.
All righty. Chalk Point.
No questions.
Harford County.
I have a couple. Regarding your establishment of technical feasibility, do you believe that there are different gradations of technical feasibility?
Yes.
Okay. So in your estimation, there's a baseline of what constitutes feasible versus unfeasible, but something could be more feasible than the baseline.
Yes.
You did not present an opinion as just solicited by other cross-examination as to the stratification of the various proposed facilities and how technically feasible they are, did you?
What my testimony provides is the level of feasibility of the various projects based on my analysis, on my evaluation.
Do you have an opinion as to the stratification between the proposed facilities?
If you're asking me if I have an opinion over one or the other, I do not. What my analysis provides is a framework that measures all of the applicants' feasibility.
Do you have an opinion as to whether or not the PSC should award credits based on the varying gradations of technical feasibility between the applications?
I think what my opinion is that the focus of my testimony was to provide another level of analysis or evaluations performed by myself for the commission to consider in their selection of the projects.
So you do think that they should take into consideration how technically feasible a particular project is when they're awarding credits?
Yes.
Thank you. I have no further questions.
Okay. OPC is still not here. Sierra Club. I mean, MEA is not here. OPC is definitely here. MEA is not here. I'm getting punchy here. Sierra Club, do you have any questions?
Oh, OPC, okay, I'm sorry, Sierra Club has no questions.
Okay, yeah, no, MEA is not here, so, yeah. Okay, so any redirect?
No redirect.
Okay, let's go to questions from the bench, starting with Commissioner McLean.
No questions, sir.
Okay, Commissioner Linton.
Yes, thank you, Mr. Chairman. Just very briefly, good afternoon.
Good afternoon.
I'm looking at your direct testimony page 13, line 17, regarding long-term project operation. I'll frame my question by simply saying that I think that over time these systems are going to be tempted to discharge far more frequently than what we may be thinking today. There's clearly the prices at the wholesale market are going up. You know, there's clearly a need for more energy in our grid, and there's more opportunities to try and make some money on both ends of the margin. So, as part of your observations here, and especially on page 14, you referenced, and from lines 8 through 10 on page 14, you referenced some financial assurance methodologies and some recycling assumptions some other things the commission should do in order to quoting you, remain assured that there's an essential components of these projects are developed. What kinds of additional obligations or financial assurances were you anticipating?
So similar to the financial assurances that we have for generation facilities, decommissioning, I think, is an important aspect that the commission should consider in regards to these proposed projects. Towards the end of the life of these projects, I think the commission should take into consideration that the project or the applicants have developed sound decommissioning plans for when to or how to decommission these projects towards the end of their life.
Okay. What about in the event that these systems are discharged more frequently than what we anticipate now, so that they begin to lose their effectiveness 5 to 10 years down the line? Are there things that we should do today to protect, not just to protect ratepayers, but the ratepayer investment, but to protect the expectation that these systems will operate at a certain level over the life of the system?
Yes. Within staff's testimony and throughout our evaluation of these projects, we inquired about augmentation plans that each of the applicants are planning to employ in regards to maintaining the operational feasibility of their projects. So we were able to identify some of those aspects of these projects, and we encouraged the commission to consider that as we encourage the applicants to definitely finalize those augmentation plans to ensure that the projects operate at the capacity that we would expect them to over the life of the project.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Commissioner Suchman.
Good afternoon, Mr. Wilson.
Good afternoon.
So in your testimony, page 21, your direct testimony, you talked about the importance of having a comprehensive approach in looking at these systems, and also sort of highlighting that they provide multiple grid services, and these are just, you've sort of identified some of the value, as Commissioner Linton has pointed out. We may not know now what other benefits are that we'll get from these battery storage systems. For the benefits you've listed, do you think that those were adequately reflected in the BCA that was performed for each of the four proposals, or are we perhaps missing some benefits?
Yeah, so to answer your question, there are definitely potential benefits that were not quantified in the BCA for good reason. Potential benefits do not necessarily equal demonstrated benefits, and so there are additional mechanisms or steps that can be taken in order to realize those benefits or those potential benefits down the line.
And I guess as we sort of get further comfortable with storage, we'll have a better sense of what benefits are out there and also how to quantify those in terms of value. So that, for example, a project that gives you energy support may be different, or energy arbitrage could be very different from projects that help you to displace transmission or distribution build out, and perhaps need to be priced differently.
Right. First, I would like to point out that these are transmission level facilities.
Right.
So they are designed to address direct transmission issues.
Right, but they still could have distribution benefits.
Indeed, and if there is a potential for them to provide indirect or incidental benefits to the distribution system, but that will entail continued communications and planning with the electric utilities or distribution utilities in Maryland. So with continued conversations between the developers and the utility companies can help the utilities identify or realize the incidental benefits that these projects can bring on a distribution level. And uniquely enough, we, the commission, the state of Maryland, is in a position to create a pathway for that to happen. We're currently in the middle of reforming our distribution system planning
That's where I was going.
process.
Right.
So, so we have we're in a unique position where the commission can encourage utilities through various means of exploring further how these transmission level facilities can help benefit their systems.
Well, and I'm assuming these developers should also be speaking with our electric utilities about where the system can get the most value in terms of where these projects are deployed.
Indeed. What the commission can do to further encourage that is providing direction to the utilities in regards to their analysis of their distribution systems and their updated distribution system planning processes. And the commission can also amend or include future RFA eligibility requirements that would encourage more analysis or more information from the applicants as to how their systems can better, or their explorations or any evaluations they've made in order to explore or realize those potential benefits. Just, having more information on the record that can be further evaluated in order to determine what these incidental benefits could possibly be.
Well, and I'm assuming also having these developers be engaged in the electric system planning process so that they can bring their expertise to the table, and they can also identify from the conversation potential projects for them.
Indeed.
Yes. Okay. Thank you.
Commissioner Hoover.
Actually, no questions.
Commissioner McLean, did I ask you already?
You did. I still have no questions.
You still have no questions, nor do I. So thank you very much.
Thank you.
All right, then. That concludes this proceeding for case 9866. Thank you to everyone. Have a great weekend coming up.